Okay, it is 8:30, Tuesday, May 23rd, 2017, week 8 of the quarter already, which means that we have 3 more weeks. After that, week 9, 10, and 11. So we're at the last quarter of it. 4 weeks. 4 weeks. And I told you this would happen very rapidly. I told you time would go fast. I encouraged you to keep up on your assignments. Most of you have. And there are a few things I'm still going to mention again that I've mentioned so many times, but I keep mentioning them every time. And to remind you. So let's go ahead and let's get started. I want to share my screen. Okay, and again, it tells you my name, my information, my phone number, and then the reminder that I've said since day 1. I've said it orally, and then it's on your course homepage that should be there when you open up your course. Feel free to email, text, or phone me any hour of the day except the 25th hour of the day. I sincerely mean that. Some students have taken me up, but not enough of you. So if you do have questions. Then reminder about research. Most students have been very good about research. They haven't just relied on the textbook, and that we encourage you to do research, because research is the way that you're going to proficiently become employable. You're going to be able to learn about information that you don't already know, because even I, as an expert in law, I've done policing, paralegal, I still do research when I want to find out something, because things are ever changing. And also I rely on reliable sources, not sources like Wikipedia, but on very reliable sources, and we have plenty of reliable sources that are available if you go to the guides, the Library Learning Center, and you can find a lot of good information to help you with your research. And I also want to keep reiterating the requirements for APA, your cover sheets. I haven't taken away points for that, but cover sheets are always required, and also citations in the body, appropriate citations, which we have information once again in our Library Learning Resource Center to help you with the APA, and to let you know that it means at the lowest level citations in the body of the paper. And why? Because citations give credibility to the statements that you include in your papers, so that when a person reads your paper, they will understand that it's you elaborating on the source that you discovered during your research in preparation for this paper. And then the listing of the resources is listed at the end on the reference page. Now, be sure that you don't have 10 references and 2 citations in the body of the paper, because you should be using your references in the body of your paper as well. Now, not every word, not every sentence, but it should be indicated throughout. And then I remind you, do not use big portions of it. Run your papers through Grammarly so that you don't get hit with a high percentage. And it's a soft check, but it gives you an idea. The key thing is the more critical thinking that you include in your papers, the more analysis, the more explanation, the more contrast and comparison, the more presentation of your position concerning the things that you research and discover, and then support it with sources, the better your papers will be. And so that's the key right there. And then coming right down to a reminder that we are at week 8 Our last lecture will take place 2 weeks from today, and that will be week 10. And that will be it for this course as far as lectures are concerned. I also want to bring to your attention before I get to my week 8 announcement, a reminder about this announcement about tutor recruiting. If you are compassionate about learning, you know, this announcement is self-explanatory, and I think that you would enjoy this. We're looking for tutors for the summer 2017 quarter, and this flyer tells you how to reach out to Bethany Marston, who is our Learning Center Coordinator for the School of Justice Studies. Gives the requirements for being a tutor, and then take a look at the work study guide to see current openings and to complete the application for that. I have recommended a few students in the past, but Bethany sent this to us, and I wanted to make sure that we call your attention to it. It's a good opportunity for you. It also helps you to pay your tuition. It also helps you to better prepare your work. And so if you meet these requirements here, particularly the 3.0 GPA, 3.5 or higher is preferred, but a minimum of 3.0, then you are possibly a candidate, and you need to read the rest of these requirements. So you could find full information too by clicking on this hyperlink down below, which is http://guides.rasmussen.edu/work-study/current job openings. Take the opportunity to do that, and then, you know, share that with some of your colleagues. But it's a good opportunity, okay? So check it out. So now let's look at our weekly announcement for this week. And so every week I encourage you. Defenses to crimes, we're going to talk about that, chapter 14 of criminal law and procedure, which I previously sent you a copy of the PowerPoint that we're going to cover tonight. And then make sure you take time to complete these activities, defenses to crimes. And then make sure that you, tonight at midnight or 11:59 p.m. Central Standard Time, submit your discussion assignment, Stand Your Ground. And I've read some of the ones you guys have presented. They've been pretty good. And I replied to a couple. I reply usually to a minimum of 2, sometimes even more. But anyway, the deadline for your initial post is tonight, 11:59 p.m. Central Standard Time, and your reply post Saturday at 11:59 p.m. Central Standard Time. Finally, you have one written assignment now, and it is insanity. Well, no, I'll take that back. You have 2, because now we start from this point on, week 8, 9, 10, and 11 with course projects. So you're going to have 2 written assignments, and you should do well on those. You get 20 points for your written assignment, insanity, and then you'll get 100 points for your course project, defenses. It would behoove you to perform well on both of those because of the fact that we are coming down to the bottom. And then finally, your weekly quiz, which I've encouraged you to take on Sundays. Some of you guys have gone on to take these quizzes right away, and you're not as done as well as you could if you waited until the end of the week. And the reason why I encourage you to wait to the end of the week is get your reading assignment out of the way and check the information that I provide to you with the PowerPoints, as well as the additional outline information that I provide you with, so that you'll be able to do well on that quiz. Remember, you will not find a final or midterm exam in this course, because you have the equivalent of 110 questions, which is 10 questions every week for 11 weeks. And that too is due on Sunday. And then a reminder that, you know, you need to finish strong. Finish strong. Don't just barely get through. Don't just throw stuff together. Don't get overwhelmed, because your reward at the end will come in the form of the knowledge that you gain, and then also the opportunities that you will gain for job opportunities, even this work study as a tutor. You're rewarded for that. And then make that a way of life. And remember my motto: adversity is the springboard to success. I shared that with you for the beginning of the course. So now let's take a brief look at our course calendar real quick here. Course calendar, which tells you where we are here. We are at week 8. Your reading assignment is given. Again, if you clicked on this, it will open it up and it will tell you what your reading assignment is, okay? And then your initial post about our lecture tonight, and then your reply post. And then it will remind you of the written assignment on insanity, which I'll elaborate on in just a minute. But if you wanted to look at the calendar, because sometimes students say, when are assignments due? The calendar is the place that you'll see where every assignment is due. And again, I remind you that satisfy the APA citations and references, adequate job of preparing assignment, which requires 2 to 3 pages, not counting the cover page or the reference page. And then I remind you that repeating the facts don't satisfy the requirement. I'm more interested in your critical thinking. We hone in critical thinking. It's one of our transferable skills that is very valuable to professional success. So make sure that you become a critical thinker. Don't just accept things just because you discovered it in research or because someone like myself said it. You can challenge. I have students that challenge what I say all the time. But when they challenge it, they need to come up with some reliable sources to back up their challenges. So that's what we want you to do in all papers, but that's a reminder there. And then, of course, your course project, same requirement, and 2 to 3 pages. And you want to make sure that you deal with the defenses, and we'll be discussing that in just a minute here. Okay, so now let's take a look at the actual module. So let's click over here. So let's start with our assignments again. Again, it specifically gives you all the facts that are involved in your written assignment for insanity. A 2 to 3 page paper, it's right at you. Some students say, well, why is that? The reason is because we believe that to prepare a paper that is scholarly and that addresses the issues adequately, and these questions here, it takes 2 to 3 pages. And of course, though, like I said again, you want to make sure that you find yourself in a situation where you adequately address each issue. Then you know the process. Make sure you submit it as a Word document. Those of you who are Mac users, which I have no clue about, you know what you have to do to make sure that that's done adequately, okay? And you'll get maximum 20 points for completing that paper on time and providing and covering the issues. Be sure that you read my comments. Oftentimes students look at the grade and then they say, well, you say the same thing. Read them anyway, because of the fact that it's a reminder. Some things I keep saying to you, and you know, if I'm saying the same thing over and over, I'm not just saying it. I'm saying it because I want you to correct it, especially the APA requirement part, especially then followed by the Grammarly part. But those are the main things, the APA requirements and then the Grammarly. But make sure that you get the requisite number of pages, the required 2 to 3 pages. And then your discussion post as well, okay? And then, finally, again, where'd you get 2 to 3 pages from? I know you didn't read the instructions. If you ask me that question, the very first line for this part of your project, consider the scenario below, which is Alan, Betty, Charles. You've gotten to know them from week 1, A, B, C. 2 to 3 page paper. Very simple. Discuss the various defenses that apply to the parties. And then be sure to discuss how the defenses of self-defense, if applicable, justifiable use of deadly force, and how the stand your ground law will apply to Alan and Betty. And you want to have citations and sources for that as well. Same process. Okay, and then finally, the last thing is your quiz. It is time, 10 minutes. Of course, you already know you have 1 opportunity, and you'll be warned 2 minutes before the time expires. So that's your assignments for the week. Let's go back and let's look into the actual module before we get into the lecture. Our objective is to deal with defenses, self-defense. We're going to deal with duress, necessity, some of the ones that are minor, but we're going to spend a lot of time talking about how defenses are presented and what they are. Again, these are your requirements for the week. And so then here we come with defenses of crime, to crimes. And we list those. The capacity, I'm not going to talk about them in detail. You read this, take time to go through and deal with these things. Read them so you get an understanding, particularly with the insanity, different views throughout the country, the Norton rule, the irresistible impulse test, the Durham test, the ALI standard, and the current federal standard. I do talk about them very briefly in the lecture, but if you don't understand them, do what I do. If I don't understand something, I do some research and find out what those rules mean and how they apply. Get the knowledge, very, very important. And understand the most popular rule, which the Norton rule. And so you want to make sure that you, and this relates to insanity. You're going to hear me talk about insanity very briefly again, and you're going to hear me say basically it's a defense that probably in 99% of the attempts to use as defense, you're not successful at it, and the system explains why. Then self-defense. Self-defense, I won my very first case, a double murder case using self-defense in a way that people didn't think would happen, but it did. The young man was acquitted of double murder even after shooting somebody in the back, and I'll explain that a little later on. Entrapment. Learn what entrapment is. What does it mean? What is it about? Who's entrapped? When is it used as a defense? How does it operate? And then go through these specific cards, flashcards at the end here, which tells you the answer to the question, you know, voluntary intoxication, a defense for a specific intent crime if it negates the existence of the element of the crime. And so then you would flip it over, and I'm just going to show you one, and then I'm going to leave it alone. So you flip it over, and then there it is. So then you flip it back over. Okay, flip it over, and then you go to the next one. Okay, so I'm going to leave those alone, but you go through, there's several various defenses that you deal with. Infancy, and then it explains to you, you flip it over, but it's also at the top. A defense to a crime because the defendant used his or her youth, because their youth lacks capacity to form the requisite intent to commit a crime. And this is not a very popular defense that's used very often now, because you know that with the high crime committed by our youth in today's time. So anyway, those are some of the things. Go through them. Take time. You also will learn some things that will help you prepare for your exam. Okay, so I'm going to leave that. And now I'm going to go right into our chapter 14, criminal responsibility and defenses. So let's get right into this. Okay, first of all, when you commit a criminal act, the law determines whether or not you actually are responsible for the criminal act or held to the commission of the crime based upon whether or not you have a justifiable or either a defense for why you did what you did. And it says criminal responsibility refers to a set of doctrines under which individuals are held accountable. So these are the doctrines that we're going to discuss tonight. Going back to the old British law, and you should know that most of our laws in the United States of America originated under the English common law, with the exception of the state of Louisiana, which operates under the Napoleonic Code. And everybody else follows the English common law. But there are justification and defenses that we're going to adequately discuss. And some of them are self-defense, a mistake of fact. How do you have a mistake of fact? A mistake of fact can come about, for example, let's say, for example, if you take, you're in an airport and you pick up a suitcase or briefcase and you walk away with that briefcase, and then you discover that that is not your briefcase. And so if someone says, oh, he stole my briefcase, well, that's not technically correct if you did it without knowing, by mistake or an error. Now, the other thing is that if you do, though, discover that this is not your property and then you don't take steps to return it, then at that point, then you do form the requisite intent to commit a crime. Oftentimes, there are people who, for example, will rent a vehicle, and the vehicle is rented, and if the vehicle is rented, it's due back by a certain date, and you do like this woman did, who didn't rent a car, just recently in the news. She took the car for a test drive, and they haven't seen her since. They don't know where she is. Well, at the point in time that she decided to go beyond the test drive and convert it to her own, at that time she committed a crime. So that's an example of that. But of course, that's not a mistake of fact. But mistake of fact does apply in situations like the suitcase. I had a coat one time I was at a place and put the coat on, and then I reached in the pocket and realized, oh, that was just not my coat. And I returned it to the person because we had similar coats. So self-defense comes about where you are able to justify the fact that you committed an offense because you were in imminent danger or to defend your own property or home, or something of that nature, or you're defending the life of another person. And again, self-defense is allowable under the law. The Fifth Amendment also furnishes immunity defense. The Fifth Amendment says that you don't have to testify against yourself. You don't have to offer information. Just recently, you probably, if you're following the news, the former, one of the operatives in the Trump administration, Mr. Flynn, has been requested to come before the for Congress and a committee to testify about possible knowledge that he has concerning Russian involvement. Well, he's already said that he's going to plead the Fifth. And the reason why is because people plead the Fifth because of the fact that you, if you give a statement, that information will be used against you, and so you could provide information, and if you're implicit in that information yourself, then you could be charged with the crime. So the Fifth Amendment says you can decline to answer those questions because it may tend to incriminate you. There's usually a card that the lawyers give their clients, and they read straight from that card, you know. Now, there are times, though, when immunity is given to an individual. We'll talk a little bit about that, and that gives that individual, excuse me, the ability to be able to not necessarily implement the Fifth, but that they are protected. But anything that they say cannot be used against him. And then there is a concept called double jeopardy. Double jeopardy occurs where you cannot be tried for the same offense twice, basically. Now, that doesn't necessarily mean that you can't be tried in state court and federal court as double jeopardy. I'll give you an example. There was a movie some years ago that came out, and the movie was called Double Jeopardy. That was the actual name. And it was a young lady that was in the movie, and I can't remember her name, but she's a country western singer. And anyway, in this movie, she was sentenced for killing her husband, and she served time in jail for killing her husband. Well, when she was paroled out, she discovered that her husband was alive and well, had faked his death, and that he had actually gotten with one of her friends, married her, moved, and she found him in another part of the country. Well, she tracked him down there, and anyway, long story short is that she went and confronted him, and he tried to have her killed. Well, the situation occurred where ultimately it came to a conclusion at the end of the movie where she actually ended up killing him. And when she killed him, he was dead. Now, she did have self-defense as a possible, but she also had double jeopardy. And the reason she had double jeopardy is because she had already served time for the crime that she was allegedly charged with and committed. And then when she actually committed the crime, you couldn't be sentenced a second time. So double jeopardy, it's a constitutional protection. Okay. Now, negative defenses versus affirmative defenses. A negative defense is when you say yes, yes. No, you deny you committed the crime. I didn't do it. I'm getting it reversed. Negative. You say, I didn't do it. I just didn't do it. Prosecution lacks sufficient evidence of defendant's guilt. An alibi is a possible defense. I will tell you quite honestly, it depends on the credibility of your alibi. There are many criminals will try to use alibi as family and friends. Those are biased, and those are extremely biased. And so sometimes it works, and sometimes they don't work. And so the point of the matter is that what you don't want to do is find yourself in a situation where you have a weak alibi defense. Prosecution must prove, though, that you are guilty beyond a reasonable doubt. Now, with an affirmative defense, such as a self-defense situation, you say, yep, I did it, but I'm not criminally responsible for what I did, such as self-defense. Or there was your mental state. You didn't lack the requisite capacity and insanity. Diminished capacity is not insanity. Diminished capacity means that it affects that you did commit the crime and that you weren't insane, but that your capacity or your decision to make right from wrong decisions was tampered with at the time of the offense. And then it says defense must prove. Now, notice this. In the negative defense, it's the prosecution's burden to prove beyond reasonable doubt. However, if you raise an affirmative defense, then you as the defendant have to prove that by a preponderance of the evidence. So what's the difference? Beyond a reasonable doubt means it's pretty clear that it goes one way or the other. With preponderance of the evidence, it's based on a weight issue. So the weight is heavier in favor of what your defense is than against it. And you should be aware that our criminal cases are tried beyond a reasonable doubt, and our civil cases, preponderance of evidence. I'll give you an example. Those of you who know about the O.J. Simpson case know that he was found not guilty in the criminal case by a jury of his peers. Well, he was then later found guilty, not convicted. That's not the term to use correctly, but he was ruled against in the civil suit that was brought by the family of Nicole Brown Simpson and Ron Goldman's family. And the evidence, by preponderance of the evidence, came against him, and as a result, it didn't result in jail time, it resulted in money damages. And they went after O.J.'s assets, including his pension and other things as well. But then somebody might ask, well, why did he end up in jail? He ended up in jail because, as unrelated to that case, is because what he tried to do was go back and take his property back and take it from the people that was involved in robbery and kidnapping. And now, just recently, it's come up that he might be paroled this year. Capacity, as I said earlier, infancy. Children under a certain age are not able to perform criminal intent. At common law, the age was 7. But then when the juvenile court system came along, the juvenile court ages limitations decreased. Kent versus United States 66. And so in the juvenile court, you are adjudicated. You are not convicted. And so our idea is to operate with rehabilitation. Now, in the normal criminal court, there's a debate about rehabilitation versus punishment. Well, in the juvenile court, our goal is always, no matter how serious the offense is, to salvage that individual and to try to turn them around. Of course, though, under circumstances that we find ourselves oftentimes now, children are tried as adults, and that's because of the fact that more and more young people are committing adult acts. You have a lot of robbery and murder, burglary, drug dealing, and things like that. Actually, minors are used oftentimes by adults, because if the minor is caught, then they'll end up in the juvenile system. And then also you should be aware that the record that you have in juvenile court is often sealed after you become an adult and is not able to be retrieved except under special circumstances. Of course, so again, elaborating on what I just said, more than 200,000 children are tried as adults each year. That number continues to go up. And then the youngest child who's been sentenced to life is 13 years old. And many are tried as adults for violent offenses. And, you know, there are a lot of social issues that are involved in the individuals who commit these crimes. And sometimes it takes a good lawyer to present those arguments on behalf of those juveniles. Now, those arguments are usually not generally presented as defenses. They are, but they're usually used in the sentencing phase to mitigating circumstances about that individual who commits the offense to decrease the possible sentence under the adjudication that the judge issued. There is no jury trials for juvenile court. Court says in 2012, 32 members of Congress urged the Attorney General to strengthen the federal regulation and prohibit states from incarcerating any person younger than 18 in an adult prison as a condition of federal funding. And the reason for that is because we know that, as a matter of fact, that if you are going to learn crime, you learn it by being exposed to prison, long-term sentences, and particularly if a juvenile is sentenced to an adult facility, they're able to be used as, and the adults are predators upon them and will convert many of them to serious offenders, even if they're not when they first are incarcerated. Intoxication used as a defense. Well, you can't use voluntary intoxication. In other words, you drink yourself, you know, so forth. But it does determine whether or not specific intent. In other words, the intoxication dulls the ability to make a decision. But general intent, most courts reject this defense for general intent crimes. So the point of the matter is that you want to make sure that you understand clearly that you probably are not going to do so very well with saying I was drunk when I did it and use that as a defense. However, if it's involuntary, involuntary comes about where someone has slipped something into your drink, or you thought you were taking one thing but you took another, or you maybe took a double dose of your medication, then the criminality is removed because it's totally involuntary. And so someone might ask this, well, if a person is a junkie and they get their medication and they use it excessively and then commit an act, is that considered as involuntary intoxication? I would submit that the answer is yes, because they're operating under a sickness that needs to be dealt with. And I think that a good defense attorney would probably at least attempt it. And through the trier of fact, which, you know, jurors, I was always taught as a defense attorney, 12 in the box. Jurors are the best route than a bench trial. And there are occasions when I opted for bench trials, but juries were my specialty because of the fact that the everyday people could relate to a lot of the things that happened with individuals. And so, but intoxication, be aware, if it's voluntary, not necessarily successful. Involuntary could be successful. Insanity, as I said before, I'll briefly talk about this. It negates the crime. The Norton rule, the probably overwhelming one that applies even with the proper standards of today, says basically that when you committed the crime, that you were, your reasoning was so defective at the time that you didn't really know right from wrong. And that's pretty much, or you didn't know what you were doing. Now, the irresistible impulse test is another one that said you really couldn't control yourself. the point of the matter is that here's the deal. And then before I talk about that, the Durham test. It says you have a mental disease defect, and you did not receive support to help you with your mental problems. Now, let me give you an example. During the entire course of my practice as a defense attorney from 1978 to roughly close to 2000, I never was successful with insanity. I only used it a few times, but each time it came back saying that the person was sane at the time of the offense. They understood what they were doing, even if the crime was heinous. But let me give you an example. We call this, many of us, the Amanda Wallace rule. And the reason we call it the Amanda Wallace rule is there was a young lady who years ago, probably in the early 90s, yeah, I think it was the early 90s, she had a child, and the child was taken away from her by the Department of Children and Family Services, which is the protective services organization in the state of Illinois. And so anyway, the child was then given back for whatever reasons, and within a short period of time after she had that child back with her, she hung that child. She hung that child. And she didn't try to run, she didn't try to hide, she didn't try to do anything. And it was determined after she was tested for insanity that she did not realize that at that time she was hanging a child. She thought she was hanging an animal or a pig or something. I forgot which animal it was. But the fact of the matter is that she was really gone. I actually had a chance to see her sometime after the offense as she was awaiting trial, and she was sitting in a corner at the women's facility at our main court building in Cook County 26 in California. And she was in a corner, and she was balled up, and she was rocking, and she was making all kind of noises, and she had, you know, if you saw her, you would realize something was wrong. Well, that's the state that she was in, even as she committed the offense, and when she was arrested, and she stayed in that state, and so that's why we started calling it the Amanda Wallace rule. And so what we really pretty much arrived at is that in Illinois, if a person is going to be found insane, they have to meet the Amanda Wallace test. Now, some people say, well, people can fake it. Trust me, if you saw Amanda Wallace and you saw people trying to fake it, you can easily determine the difference. So anyway, let me elaborate a little bit more on insanity before the ALI standards, the substantial capacity test. You had a capacity to be able to commit the crime. Current federal law, though, the Insanity Defense Reform Act of '84, required psychiatric evidence of an impaired volitional control was not admissible. Psychiatric evidence, though, may be used to negate specific intent, and that was the key that was being used here. Here it was used broader. Here it was limited. There must be clear and convincing evidence, and the defendant, of course, had the burden shifted to him, as I had stated earlier. And some states have abolished the insanity defense, so it doesn't exist at all. Illinois still has it, but as I said, it might as well not have it in most cases. Clark versus Arizona, 206 U.S. Supreme Court case in which this person was charged with killing a police officer. He said that the insanity defense was due to he suffered from paranoid schizophrenia. Well, in Arizona, the law did not include part of the Norton rule. The defendant did not understand the Nature and Quality Act, and Clark was convicted. He appealed, and the U.S. Supreme Court ruled that the Arizona statute did violate his due process rights, and that states may refuse to allow psychiatric testimony short of insanity to negate mens rea. So the point of the matter is that it does help in some situations here. And if this person was genuinely a paranoid schizophrenic at the time of the offense, then it could be a possible defense. But it's not the easiest thing to prove. Remember, what will happen is that the psychiatrist that the state provides will have a chance to present their position of examining the individual. And then sometimes the defense attorneys, if the family is wealthy enough to be able to pay for the expensive cost of a psychiatrist to be able to go through and reach maybe a possible second conclusion, then it'll be up to the trier of fact then from that particular point. They're excused defenses. These are the defenses that says, well, you know, I did it, but, and I was talking about them earlier. Duress, the use of illegal confinement or threats of harm to coerce someone. Now, we call duress what we call gun at head duress. Now, that doesn't, it's only a pictorial thing. Gun at head. If somebody has a gun at head, someone will do pretty much what that person is telling them to do because of the fact that they know that imminently they're in danger or that someone else is in danger. But that's pretty much the standard that you have to have for duress. Necessity. Forces beyond the actor's control. If a person says economically they did it to survive, such as stealing a loaf of bread to eat, that may be considered in terms of mitigation, but it's not considered as a defense because it is against the law to steal. It is against the law to rob people and commit theft. So you can't use necessity. I need the food and I took it and I ate it. That you can eat it, but you're going to go to jail. Consent. Physical injury consented to must result from conduct that is not intended to cause serious injury. No consent. Oh, the person consented to it. Not going to fly. Mistake of law. Erroneous opinion of legal principles, such as you might think, for example, that you took some property, as I said, in error, or a misapplication of the law. It depends. Like, for example, speeding. You can't use a mistake of law because you thought that there was a 5-mile rule. People think that. When I was a prosecutor in a local municipality, people would come up to traffic court and the signs posted said 35 or 30, and they would come in and says that they were doing 35 or 5 miles over a rule. I said, there's no such thing. The judge said that too. But they were of the opinion that there was such a thing because some people thought that you could go 5 miles over. What that person really did was save me the necessity of proving guilt. They admitted themselves. Ignorance is not an excuse. Okay. Mistake of fact, innocent misunderstanding of fact rather than forming criminal purpose. I talked about those kind of things earlier in this lecture. So those are some of the excuse defenses. In Lambert versus California, the Supreme Court reverses conviction based on the notion that defendant must be notified of the required acts. Lambert was convicted of failing to register with the city as a convicted felon. He was never given notice that he had to register. He appealed his conviction, stating that his due process, in other words, he didn't have an opportunity to know about it before he violated the law. And the court said, yes, that's true. Now, remember this. The information is, if it's readily available to the individual and then they don't follow up on it, then that's a different story. But, and you know, that's like, for example, a person comes and says, oh, strict liability issue, not having their license, and they didn't know their license was suspended. That's not going to fly. That's a different scenario altogether. Now, we're going to get into self-defense now. I said we're going to elaborate on that a little bit more. Use of force and self-defense. Now, you need to be aware of the fact that in these kinds of cases, the amount of force to meet the force must be comparable. For example, let's say, for example, if I raise my fist to hit you, and you take a gun and shoot me, then you can't argue self-defense, because the force that I was going to implement on you was with my hand, but you took a weapon to defend yourself. And so that's a general rule. Now, it is, however, arguable. Let's say, for example, if I raise my hand and I'm a registered boxer, I'm a boxer, professional boxer, or either if, for example, I am a registered martial artist, or I have my black belt or some kind of belt in martial arts, and then I raise my hand to do it, and then you shoot, there might be an argument, because my hands are more than just hands now. They're weapons that could be deadly to the individual. Also, the size of the person under attack and the person attacking may be a basis for it as well. But you can't use deadly force in a non-deadly situation. And, you know, you'll find that the whole argument in law enforcement is that people use deadly force because they feel that they're in fear of a person. Even if the person hasn't done anything yet, if they make a move or something, maybe even reach into their pocket, they feel like they take a weapon and shoot them, that's adequate. Those people have been found guilty of committing excessive force crimes, and so you can't do that. You have to be able to at least put it in a position. Now, let's say, for example, as I had a person one time when I was a police officer, to pull a gun on me, and it turned out to be a toy gun. I could have shot them, but I didn't. But I got them to drop their weapon because I got my weapon out on them and kicked it over to me, and it turned out to be a toy. If I had shot them and killed them under those circumstances, it would not have been excessive, and it would have been proper under the circumstances, because it is not my call to determine at the time whether that's a toy gun or a real gun, or whether it's a loaded or an unloaded gun. That is not my call. My whole thing is that when a weapon that appears to be a weapon that could create serious injury or great bodily harm or death to me or someone else, I can use deadly force in that situation. Self-defense is what we call, already we said, is an affirmative defense. In other words, I have said, yes, I did do this, but I did it because stand your ground laws, which Florida has one, and it became really famous because of the Trayvon Martin case. And so as a result, many jurisdictions have laws that say you don't have to escape. You don't have to escape. You have a right to defend yourself as long as it is commensurate with the act that the person is performing against you. We had a pattern this week in our assignment that involved the stand your ground laws. But what we basically argued is that that person has a right to defend themselves against this person because they were the aggressor, and that person was at a place where they had a right to be, and then they didn't use excessive force, and they didn't have to retreat. It wasn't necessary, because it's been presented that people can be hurt retreating, or that people may not have enough time to retreat, and those kinds of situations. So it's an affirmative defense. Now, let me talk about self-defense in a case that I had, and this was before the stand your ground laws came about. I had a young man in my very first serious criminal defense case who was charged with double murder. And the scenario was such that the defendant had a crap game going, and he opened the door to let these two guys in. And when he opened the door, he stepped down some stairs, and those individuals went past him and went up the stairs. Well, as he was locking the door and they got to the top of the stairs, these two guys took out weapons and announced that they were holding up the game. They were going to rob everyone there. Well, my client had a gun too in his belt. He got his gun out and he kneeled and shot those individuals, both of them, and they hit the ground. And then he came up the stairs, and then he shot those individuals and emptied his guns in their backs, and then he fled. And so then I was hired to defend this young man. Well, when I interviewed him, he told me what happened. It was corroborated by the witnesses that were present there. And so I said, okay. I said, I'm going to go with self-defense. Well, immediately people started raising the issue, said, wait. Yeah, he had self-defense up to a point, but then he shot them in the back several times. I said, well, the initial act was not to shoot them in the back, and so forth and so on. So that was going to be my defense. That was it. So then here's what happened, guys. I ended up standing with my position, and then I issued my subpoenas for different witnesses, and one of the key witnesses was the medical examiner. When I got the autopsy report, I read an autopsy report that it was clearly stated that the death of both of those individuals was caused by a single shot, consistent with his face upward and pierced the aorta. The guy was a good shot and shot them both. So therefore, when they hit the ground, they were dead. So the truth of the matter is that I got the report, I read it, and so when I got the examiner on the stand, I questioned him about what he had written in his report, and he supported that. And then I asked him this question. I said, so when he shot them, I said, by the way, did your autopsy discover any other shots? He said, yes, there were several bullet holes in the back. I said, okay, so would you, in your professional opinion, and I asked this question, say that the cause of death was, as you said in your report, consistent with the single shot that he was facing those individuals, which would, of course, support the fact that there was self-defense? And he said, yes. I said, but, and I said, nail it down. I already knew the answer. I said, so they were dead when they hit the ground? He said, yes. So what about the shots at the back? He says, they didn't mean anything. They were dead already. And I said, thank you. So therefore, the jury heard that, along with some other things that I presented. But they said that was the critical issue, that it was established that young man that I defended had committed the crime of murder as a charge, but that self-defense was the affirmative defense that we presented, and it was successful. So you can present self-defense in some novel ways, but you have to do your homework there. Now, the objective test versus subjective test. There are also times for other defense, the battered women and child syndrome. What that is, it means that you committed the force against the individual because they constantly beat you. In domestic violence situations where there are individuals who are beaten, particularly females, that they will at some point, they've just been so beaten into submission that they will, the first opportunity they can, they will, rather than just leave because that person will track them down, is they will kill that individual. And I've seen it go both ways. I know how to put together a battered woman's case because I grew up in a home of domestic violence, so I know how to present to a jury. But not all lawyers know how to do that. And so very seriously that it's clear to jurors particularly that a person, their whole, and there are experts who would testify to this, that the individual fearful of that individual and have had history where that person has come after them when they have left and threatened them, that they feel that if they didn't put an end to it, that it was going to continue. And so that's kind of the battered women and child syndrome. And it's used as defense. And if it's not used as defense successfully, then it is certainly used in mitigating circumstances and decreases the sentence that that person could receive. Defense of others, you can use self-defense, defense of others, and defense of property. Of course, though, it needs to be in a situation where pretty much it's your own place. Your home is your castle, and a person can be killed if they break into your home or they attempt to threaten you in your home, and those kind of things that you can use force against that individual. But the key thing to remember is that it must be necessary and reasonable under all the surrounding circumstances. And, you know, like I said again, deadly force can be repelled by defending yourself in a deadly fashion, and vice versa as well. That's kind of like a summary. And then this is example, stand your ground. And, you know, if you read this PowerPoint, it tells something that, and it still disturbs me today, that Zimmerman was working as a watchman and claimed that Martin had charged him and threatened his life, and that he said he acted in self-defense. Now, it says Zimmerman had watched Martin walk in a neighborhood and called the police to report that he was acting strange. And so police told him to stay away from Martin. Now, he ignored that. He ignored that and approached Martin. To me, that's a troubling issue in Stand Your Ground. The argument in Florida law is that he had a right to be where he was and so forth and so on. However, though, the police had told him what to do. But he went against what the police said, and he took it into his own hands, and he approached the young man. And then he was charged with second degree. That's why they didn't charge him with first degree murder. So then the question is whether Zimmerman was acting in self-defense. And so the jury said that he was acting in self-defense and found not guilty of second degree murder. Many disagree, including this individual right here, myself, because, as I said, the key issue is that this individual ignored the police instructions. And if you, as a individual, ignore police instructions and you do something, you could be found guilty of a crime in a situation there. So my question is, why this? We don't know the answer to all of that, but it's still one of the contentious issues, even today, 2017. Okay. The forms of immunity. I talked about this a little earlier. There's different forms, though. There's constitutional immunity. Then I told you about the privilege against self-incrimination, the Fifth Amendment right. Now, the immunity can be transferred to a witness, as I said, where a person is granted what we call use immunity for purposes of testifying and presenting the evidence. In other words, basically what's being said is that you can tell in the ordinary circumstances that we will use it against you, but in exchange for the information, we won't use it against you. Then your Fifth Amendment right should go out the window from that particular point, because then you are not going to be incriminated in what you testify to. So you're free to testify without any repercussions. Other forms of immunity, and that's a contractual immunity, such as witness protection, where a person is protected and put away to a place sometimes even, but even like what I just said a few minutes ago, where your statements are not used against you. Diplomatic immunity, such as a person from another country comes in and commits a crime. It's an example coming up in a minute. Then that person is immune from prosecution because of the diplomatic rules. They're from another country. They're an ambassador or a prince or a king or something. Legislative immunity applies in the legislature, same thing, that an individual can testify without being prosecuted. There's a deal that you can provide the information to the legislature, and that kind of like would fit with the case of the guy from the I can't bring his name now. I said it earlier, but you know what I'm talking about. Testify about the Russian issues that are involved there. So, diplomatic immunity protects government officials in foreign countries from undue prosecution. On January 27th, here's an example, 2011, U.S. diplomat Davis killed 2 Pakistanis. He had admitted to shooting 2 men after they pulled alongside him on a motorbike. American officials said he saw they had a gun and he believed he was about to be robbed. The Pakistanis, though, charged him with double murder, ignoring his immunity status. He was released from custody after payment of $2.4 million. And so the question of diplomatic immunity is a law that exists to protect diplomats or representatives from another country when they are in another country. Okay. Double jeopardy, we already talked about that. Statute of limitations. Statute of limitations is very simple, that there are certain times that a person can be prosecuted for a crime. There's statute of limitations for almost every crime that exists. Now, just recently here in Illinois, there is a bill that is either pending, I don't know if the governor signed it or where it is, that extends the statute of limitation for prosecution for rape cases, especially in situations where there were minors involved and they were the victims. Came about because of the fact that at some parochial schools there were males who had been sexually assaulted by the priest. But anyway, regardless of the statute of limitations, there is rarely a statute of limitations for murder. It can go on and on and on. For federal statutes, 5 years for non-capital murder. Every state has different limitations, though, and some states have removed limitations for rapes. I already told you what's happening here. So, of course, those defendants can waive the right if they need to gain time for plea bargaining. Let's say, for example, a statute of limitation is going on, and you're near the time. Well, if there's a need for plea bargaining or investigation, the clock stops on the statute of limitations and starts after that again. Okay. But statute of limitations limits the time that a charge has to be brought, not completed, but just brought, come forth. Entrapment is when the government agent takes someone who is not about to commit a crime and puts them in a position. You're walking down the street, mind your own business, and 2 guys walk up to you and say, hey, I got these drugs. You want to buy some drugs? Now, they may know something about you, or they may not know anything about you. And then you turn around and say, yes. Well, then they'll arrest you for buying drugs. That's entrapment, because you weren't of the state of mind. They brought planted the idea, and so as a result, now it's a phenomenon that's come about in modern times. As it says here, it was not part of the common law, and it's not in the Constitution. But the problem with entrapment, as it says in the subjective test of entrapment, is that it does not establish rules for enforcement for police. So sometimes they get around it. But the objective test of entrapment, where the court establishes that the police use improper methods, and that's the one that you want to operate under. The key thing is this, is that, here's the deal. First of all, number one, somebody can come up to me all day long and offer me something, and I say no. I have had people to come on the streets and say to me, hey, I got these watches, man, you need to get them, man. I just got them, man. I just got them from a place. That leads you to believe that they're hot. Well, two things you should be aware of. Number one, you don't want to do that because of the fact that that could be a form of entrapment if that's a law enforcement officer doing it. But the other thing is that it's usually a con. I had a guy come to me one time, try to sell me a Rolex. And so, I just looked at it and I said, thank you, but no thank you. I wasn't buying it anyway. But then I told him, I says, hey, homeboy, there's no D in Rolex. And he ran then from that particular point. So anyway, the bottom line is inducing someone to commit a crime when they're not of the state of mind to even want to commit a crime. Okay. Jacobson versus United States, Jacobson versus United States, in which the Supreme Court reversed a conviction for solicitation of sexually explicit materials, arguing that the government agent may not implant a design, in other words, an idea in an innocent person's mind and then induce commission of the crime. Jacobson, he was a sex offender, so they already knew this. So he was targeted by the police, and they sent him mailings of sexually explicit materials over a period of 26 months. And communications decrying censorship and question constitutionality of the government efforts to restrict sexuality, explicit materials. The bottom line is that they were setting him up, and they knew what they were doing. But you can't do that. That's clear. They already knew that that person was prone to that, and so therefore you can't do that. That's clear entrapment. Selective prosecution is basically singling out individuals on the basis of race, religion, sex, national origin, or those kinds of things. The only problem with using that as a defense is that, as it says in the second point, is that you have to prove that others in the same kind of situation have not been prosecuted for the same conduct. Now, that's not easy to prove because of the fact that it's not a record that the person was not prosecuted. So it's hard to use, and it's oftentimes rejected as a defense. In other words, people say, well, the numbers show that there are more minorities being prosecuted for this offense than Caucasians. Not very going to fly very well because each is taken generally on a case-by-case basis. Okay, we're almost done. And then the United States Supreme Court held that passive enforcement of prosecuting only those non-registrants who reported themselves or were reported by others was not a violation of the First or Fifth. This person, Wright, had not registered under the Selective Service Act and was convicted for failing to register. He argued that he was singled out. Well, the fact of the matter is that it doesn't matter whether he was singled out, but he was one. It reminds me of defense that people would use when it comes to traffic court. When I was a prosecutor once again, they would say, well, I was just in the flow of traffic. Other people were speeding too. And so the judge would say, well, yeah, so you actually were speeding, yes, but there were others too. Well, now you're the one who got caught. And that's the bottom line here, is that Don't try to use that as a defense. It's not going to fly. Novel defenses. This is the last PowerPoint. Novel and innovative defenses. These are some defenses that, lawyers get very creative. Usual religious beliefs and practices, such as failing to obtain medical treatment for a child due to religious beliefs, is not a valid defense. You cannot prevent that child from receiving medical treatment. It is not a defense that your religious beliefs prohibit you from doing that, even though that's your child. That is not a defense, and it will not fly anywhere, ever. The victim's negligence. Say the person was negligent themselves. I've seen situations in rape cases where individuals try to use the way that person dressed, the way that they looked at them, the way they smiled, and those kinds of things. Not going to happen. Not going to happen. PMS, person committed the act because they were under the influence of PMS at the time. Well, that may be a mitigating factor, but it's not going to be a successful defense. Compulsive gambling. I have an illness, a sickness, and so I continue to gamble, and so forth and so on. Still not going to be a successful defense, but might be mitigation. PTSS, post-traumatic stress syndrome. It's not going to successfully fly as a defense, but it could be used in mitigation. Oh, the famous junk food defense. I've seen that tried, and it's a novel approach to say that it's the food that I ate that caused me to commit the crime. Well, you voluntarily ate the food. So it's almost like voluntary alcohol or drinking, intoxication. It's not going to fly as a defense. Same thing with television intoxication. Again, mitigation, maybe, I don't know about the junk food defense even being mitigation, but the television intoxication, it's arguable, but it's de minimis. Pornographic intoxication depends on the circumstances. I doubt if it's a defense successful, but it could be a mitigating factor. XY chromosome abnormality. I haven't seen that fly at all, ever, in a defense case. I've seen it used, though, in mitigation cases. So the point of the matter is these novel defenses, people can try. There's some defenses that just, just came out of the blue, and people would try to present them. And you know what is the most interesting thing is that when a jury trial takes place, sometimes people will go for them. But I would say that you're reaching for straws in those kind of scenarios. So that is it. That is it for today. None of you made it, so I am going to remind you that I will be sending you the PowerPoint for week 9 next week. And I already told you about reaching out to me. I wish you guys the best for the rest of this week. Next week is Memorial Day. The campuses will be closed, but that online classes, it doesn't really affect us because we don't do any lectures or anything like that. But you make sure you keep up with your work anyway. So that's about it. I'm going to say good night to each of you.